Okay, I think we are live now. All right, hello, thank you for joining us. The Cincinnati Bar Association is pleased to present a series of public information sessions answering common questions about legal issues in the wake of COVID-19. Today's session will focus on labor and employment. Our attorney panelists today are Kelly Malloy Myers with Freaking Myers and Roll and Matthew Okiishi with Finney Law Firm. Thank you both for your time and expertise. If you need legal assistance, please go to cincybar.org/LRS for our lawyer referral service. Questions answered are not to be considered specific legal advice and are meant to address general areas of interest regarding these issues as they relate to the COVID-19 pandemic. Kelly, we'll start with you.
Hi there.
Hi. Our first question, what recourse do people with compromised immune systems have if their employer insists that work resume in person and the employee does not feel safe?
So this is a very difficult question. A lot of people are worried about their health and returning to work when the COVID-19 crisis is still ongoing. The Americans with Disabilities Act and its state counterpart under Ohio law require accommodation, reasonable accommodation for disabilities. So if there is an underlying health condition or medical condition that may put the employee at higher risk if they return to work, I think that they should talk to their physician, their doctors, and then talk to their employer about whether there can be some accommodation to protect them, particularly because of enhanced risk of serious, having a serious complication if they are to contract COVID-19. So I think just keep the dialogue open, tell the employer that you've got some concerns, and if you can work from home, you can request continuing to work from home if that works. If it's not a job that would allow you to work remotely from home, there may be other accommodations that can be in place, such as moving your desk away from, say, a lobby or other employees, things like that. So once the employee says, hey, I'm concerned and I think I need some accommodation for my underlying health condition that puts me at a higher risk for experiencing a bad outcome with COVID-19, the employer has an obligation to engage in what's called an interactive process, which is basically just talking it through, talking with the employee about what can be done to accommodate that those medical conditions and that concern. Obviously, talking to your physician, having them provide some backup is helpful as well. And I think most employers do have a concern about their employees and want to keep them safe and healthy. And so I think it's good to have that communication and speak up. Some employers may not be bringing everybody back at once or may not be able to bring everyone back at once. They may be willing to put that employee, keep them on furlough or layoff for a period of time while they bring other lower risk employees back as well. So just open that communication door, talk about accommodation, and I think that's the first step.
Sure, good to know, thank you. Matt, can an employer be held responsible if clients or staff become sick?
It depends. It depends on a variety of factors, some that we know and others that are very case specific. Generally, OSHA has a general duties clause, which requires employers to furnish a place of employment that is free from recognized hazards. So at present, most, if not all, workplaces are probably not recognized hazards under OSHA's general duties clause. However, that situation can change quickly. As we know, the virus tends to spread quickly in confined areas. And so if there's a situation where an employer is bringing people back to work, is not maintaining social distancing, is not taking the required precautions to maintain a safe work environment, and there's an outbreak, there's a possibility that OSHA liability could attach. However, OSHA has not really issued any definitive guidance on that point. There are two bills that are currently pending in the one in the Ohio General Assembly and the other in the U.S. House of Representatives, which both seek to reduce or eliminate employer liability. The House bill by Representative Mike Turner out of Ohio's 10th would give immunity for any injury resulting in employees contracting COVID-19 unless the employer was violating state or federal law. And it also provides a mechanism for employees to address concerns regarding safety with the employer without having to fear any sort of retaliation. And if an employer can't meet those accommodations, the employee is entitled to still be eligible for unemployment benefits if they chose not to return to work. The Ohio bill is Senate Bill 308, and that would provide a really blanket immunity to employers for exposure to any illness during the crisis. It would also provide immunity to service providers, which is essentially any employer in the state, for any injury that arose from them performing their duties. Rebutting that would require a person to show by clear and convincing evidence that the business acted intentionally. And it would also apply retroactive to the date the emergency was first declared.
Okay, interesting. Thank you. Kelly, third question. What rights, recourses, or protections do undocumented immigrants have in employment during COVID-19?
Well, undocumented workers are protected by the same health and safety laws and the same anti-discrimination statutes, such as Title VII, which is a federal law that prohibits discrimination on the basis of some protected classifications like race, national origin, gender, etc. The risk, however, for undocumented workers is that if they complain, they could put themselves on the radar for ICE or other government entities that may then seek to try to deport them if they're undocumented. So I think the safest bet is perhaps concerted activity, working with your coworkers, because the problem is that undocumented workers are some of the most vulnerable workers in the country. We've heard reports of, for example, meatpacking plants. We've heard that's been the subject of many reports lately, where COVID-19 is spreading through those facilities and factories, or has spread due to a number of reasons, close quarters of the employees, etc. So if there is, if the undocumented worker is fearful of the working conditions or the job, what's happening on the job, I think it's important to act in concert. There's some protection in numbers. So work with your coworkers as a group. That's also that kind of what's called concerted activity, which is basically just group activity, working with your peers and your coworkers, can also be protected by the National Labor Relations Act that protects concerted activity or employees working together. So I think that is probably the best bet for undocumented workers. But I certainly think that, you can't minimize the risk. There's risk there, and I encourage undocumented workers who are concerned about their workplace to contact an attorneys or their private organizations and agencies that can provide advice and guidance as well.
Great. Question 4 is for Matt. Can an employer compel you to come back to work if you believe it is an unsafe environment, but they do not?
On its face, no. An employer can't they can't come to your house, drag you out the door, kicking and screaming, and say, hey, you're going to come to work today. That's really what the question is getting at. Can an employer fire you if you refuse to come to work and you think it's unsafe? Standing alone, one employee, yes, the employer can do that. But like Kelly was saying to the previous question, there is often strength in numbers. Concerted activity, that is multiple employees bringing concerns about the terms and conditions of their employment to the notice of their employer, that is protected under federal law. And so an employer may be more willing to have an open dialogue in that situation, maybe more flexible about promoting telework, which is, as we all know, kind of on the rise. And I mean, we're doing it right here. So, a dialogue is important, but an employer can't drag you there, but there's certainly a risk of termination.
Okay. Kelly, what if my employer is not providing the correct socially distanced space to work in, i.e. the ability to work 6 feet away from someone else?
So again, I think hopefully most employers are providing safe workplaces for their employees, following the guidelines that are set forth by Governor DeWine as we are returning to work in Ohio. You know, just from a business justification standpoint, the employer shouldn't want to be the one that's a hotspot and suddenly get negative press that they've been a hotspot in Ohio and they've been the employer who has had an outbreak of COVID-19 among their employees. So hopefully, if not motivated by just concern for their employees, they're motivated by trying to avoid negative publicity. But if your employer is hopefully the exception, what is the exception to the rule, and they're not following the guidelines set forth by the health officials and the experts to return to work safely. One, we're going to sound like broken records, but protected activity is I think, concerted group activity will be protected activity. Go to your employer, strengthen numbers. If you can get some other coworkers to go with you to say, hey, we're concerned about this. What can we do to make sure we are following these guidelines? That's one option. And then another option is to report your employer to the local health department and let them come in and investigate and take some action if necessary.
Okay, good to know. Matt, what if my employer is not adhering to increased sanitation and COVID-19 guidelines in the workplace?
Very much along the same lines as what Kelly was saying. Of course, the first step should probably be for workplace harmony to have a dialogue with the employer about how they need to kind of clean up their act. And, of course, again, there's strength in numbers. If you have a concern, it's probably very likely that another employee also shares the exact same concerns about the safety of their workplace. Nobody really wants to carry this disease and transmit it to anybody else. Another option is that there may be a good faith reason for believing that, the employer is breaching its general duty under OSHA to furnish a place free from recognized hazards. They do have to make it somewhat safe. If there is somebody that tests positive for COVID-19 and then the employer still continues to keep people, say, working in a tight-knit environment without shields or, not requiring the use of masks, that may require reporting up to the proper authorities, including the local health department.
Kelly, what's different about unemployment under the CARES Act in Ohio than regular unemployment?
There have been a lot of changes to unemployment as related to the CARES Act. A couple of things that we'll focus on. One is that the period of eligibility can be extended for an additional 13 weeks for a total of 39 weeks. The period of unemployment, the maximum period of unemployment benefits was 26 weeks. Now, under the federal amendment, the federal acts can be extended to 39 weeks. There's also a federal supplement. So that is an enhancement to state unemployment benefits of $600 per week for eligible claimants. Now that benefit extends through July 31st of this year, so July 31st of 2020. It may be extended. Right now it isn't. There's been a House bill that's been in play, a federal House bill to extend that for additional period of time, but the Senate still has to take it up. So right now it's through July 31st, and we'll have to wait and see what happens or if any further legislation providing additional benefits. The other big change under the federal unemployment CARES Act is that many employees who weren't otherwise eligible for unemployment can now be eligible, such as gig workers, freelancers, independent contractors, part-time employees may all be eligible for that federal supplement. So Ohio has really a great website for questions about unemployment pandemic eligibility, and it's unemploymenthelp.ohio.gov, and there's lots of FAQs that are listed on there that can give answers to questions such as eligibility and who can apply and how I apply and what to expect in terms of a waiting period. So if anyone's having questions or problems with applying for unemployment, that's a great place to go. It's very difficult to get anybody on the phone at unemployment right now. Also, I think the unemployment is working through some initial backlogs with respect to unprecedented numbers of people who have had to apply for unemployment due to layoffs and furloughs related to the pandemic. So they're getting through that. I think times are hopefully going to be quicker in terms of getting benefits allowed, but that's a great place to go for your initial questions. Again, it's unemploymenthelp.ohio.gov.
Wonderful. Thank you for sharing that. The next question, Matt, if my position was eliminated or I was terminated from my position because of COVID-19, what is my recourse?
So Ohio, like many states in the U.S., well, I think almost every state in the U.S. is what's called an at-will employment state, which means that an employee can be terminated at any time for any reason that isn't prohibited by law. They're subject, of course, to namely our anti-discrimination statutes and others. So unfortunately, a termination based solely on COVID-19, either a lack of work or well, probably that's what it is, a lack of work. There isn't really a recourse for an employee that's been terminated solely for that reason. You know, there is a possibility that, you know, if only one employee is terminated for COVID-19 reasons and everybody else is there may be a more nefarious reason for that. But generally, there isn't really a remedy for most employees in the state. However, employees who have employment contracts, are in the civil service, or are members of a union, they may have rights of a hearing and appeal for their termination, depending on the specific law or contract that governs that employment.
Okay.
And let me just add to that. I think what we're going to see is employers, and this is the cynical me talking, but I'm concerned that employers may use this as an excuse perhaps to, or kind of a smokescreen or a pretext to make some employment discriminations that are in violation of the anti-discrimination statutes. And I think we're going to see this when people are being called back to work. So if you've been furloughed, everybody's been furloughed. Okay, fine. But when your employer starts calling people back, if the employer is requiring everybody to apply for their positions again, or you find out that all your coworkers who in their 40s have been called back, but you're an employee in your 60s and you haven't been called back, then that certainly could be an age discrimination claim that you should vet with an attorney and reach out to an attorney through the Cincinnati Bar Association Lawyer Referral Service, or Matt or I to answer those questions, because I think we're going to, I hope that we don't, but in other times where we've had recessions, that's certainly been a concern, where employers don't call back. It's basically age related, but an employee that's perhaps taken FMLA leave in the past, or has needs accommodation, you know, the employer forgets to call them back. So if that's happening and you're not being called back and you know that your coworkers are, reach out to an attorney.
Absolutely. Thank you. Throwing it back to you, Kelly, to continue on the unemployment tack. The next question is, what should I do if my unemployment was denied during COVID-19?
So there is an appeal process through the unemployment system. So if your unemployment is denied and you think that the denial was an error, that you should have been allowed, you should appeal. It's very important that you appeal within the deadline set forth by Job and Family Services. There'll be a deadline in the documentation that you receive. Make sure you appeal by that deadline. And there's a couple of what I call paper appeal steps where you just kind of appeal and say, hey, I think this was an error. But ultimately, you'll be given a hearing with a hearing officer, and where you can explain why you think that you did fall within the qualifications for benefits and why the benefits should be allowed.
Okay. Matt, does my unemployment backdate to the day I became unemployed?
No, but it does backdate to the date that you applied for the unemployment. That's the minor but significant detail
Mhm.
here. So when it's ultimately, when you ultimately start receiving those benefits, they will be backdated, but only to the date of the application, not so much to the, or for the weeks that the application has been pending, but not so much to the date of the termination.
Interesting. Okay. Kelly, I'm sorry, my employer is requiring all employees wear a mask and or gloves, but I don't feel comfortable doing that, or because of medical reasons, I can't. What are my options?
Well, those are two different questions and they're two very different answers. If you can't wear a mask or gloves because of a medical condition or disability, that can be protected and require reasonable accommodation under the Americans with Disabilities Act or Ohio state law. So say, for example, you have a latex allergy and you can't wear gloves. As we talked about at the beginning of this session, talk to your employer, ask for accommodation, and engage in that interactive process. If you can't wear a mask because of some breathing issues, if you have COPD or something like that, then again, talk to your doctor, get some medical documentation, talk to your employer. There may be other things, maybe a face shield can be used instead of a cloth face mask that would, be right up against your face. That might be an option that is a reasonable accommodation that the employer can provide. Now, if you don't want to wear a face mask or gloves just because they make you uncomfortable, the employer can then terminate your employment. And generally, you wouldn't be eligible for unemployment benefits if you just refuse to abide by the private employer's rules and regulations with respect to wearing masks and gloves in the workplace.
Okay. And the next question is also for you. Let me pull it up. How can I become eligible for FMLA under the CARES Act?
Okay, so I have to read these. There's a list of several ways. So the FMLA was in place pre-pandemic, the Family Medical Leave Act. It provided unpaid leave job protection for up to 12 weeks for employees who were eligible under the FMLA. So under the regular FMLA, the employer has to have 50 or more employees. The employee has to have been employed for a year. They have to have worked 1,250 hours in the previous year. And if they have a serious health condition, which is something certainly COVID-19 would qualify as a serious health condition, they could receive 12 weeks of unpaid leave and their job would be protected during that period of time. So there have been some, under CARES, there have been a couple of amendments to the Family Medical Leave Act that apply. So right now, there's the Family First Coronavirus Response Act. There's tons of acronyms. We can't keep them all straight, but under the FFCRA, it allows an eligible employee to take paid sick leave. So that's paid instead of unpaid, but it's only for 2 weeks. The paid part is only for 2 weeks. An employee is eligible for that if they are subject to federal, state, or local quarantine or isolation orders related to COVID-19. They're advised by a healthcare provider to self-quarantine because of COVID-19. They're experiencing COVID-19 symptoms and seeking a medical diagnosis. They're caring for someone subject to a quarantine or isolation order, caring for a child whose school or place of care is closed for reasons related to COVID-19, or they're experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services. So that employee, if you meet one of those 6 classifications, they are eligible for paid sick leave immediately upon hire. It's not that year waiting period like we have under the regular Family Medical Leave Act or FMLA. Full-time employees are eligible to receive 80 hours of paid sick leave, and part-time employees, it's prorated to the average number of hours that they work. There's a cap, let's see, the cap is $510 per day of the paid leave. Now there's also the Emergency Family and Medical Leave Expansion Act, which is another CARES Act amendment in place to the FMLA. And that provides up to 12 weeks of family and medical leave if an employee is unable to work or telework because the employee must care for a child whose school is closed, whose school or place of care, daycare, is closed because of COVID-19. The first 2 weeks is unpaid, so it's the kind of the flip. I think the idea was that the employer would provide paid sick leave in this situation for up to 2 weeks. And then after that, the employee is eligible for some pay. It's basically at 2/3 of the pay, up to $200 per day. So it's partial paid leave. I wouldn't say it's full paid leave, but it's partial paid leave. And both of these provisions under the CARES Act applies only to employees with fewer than 500 employees. So it's smaller employees, smaller employers that are covered by these two amendments or acts that are in place. And both of these are set to expire at the end of 2020. So provides a little more protection than what we currently had with the FMLA.
Thank you. That was very thorough. That's a lot of nuance happening.
Well, right. I mean, there are a lot of changes. There's been a ton of legislation related to this pandemic. And sometimes, I'm sure Matt agrees with me, it feels like we're trying to drink out of a fire hose. There's a lot of changes that are in place. There's potential changes that are coming down the pike. And, you know, that's why we're here and why I'm so happy that the Bar Association is doing this for people, because I think a lot of employees need answers to questions every day.
Yeah, absolutely. Okay, we are coming towards the end. Matt, the last question is for you. If I am required to self-quarantine by my job after returning from personal travel, am I eligible for emergency paid sick leave?
So, probably no. No, I think I can answer that with a straight no. First, there are only 6 reasons why an employee is going to be eligible for emergency paid sick leave. Kelly's already done me this huge favor by listing them all off very thoroughly. You know, is the employee subject to a quarantine? Have they been advised to quarantine by a physician? Are they experiencing symptoms? You know, are they caring for someone that's seeking one of those 3? Or are they taking time to care for a child whose school or healthcare provider or daycare provider has been closed? 6th reason, you know, HHS determining a substantially similar condition exists. That's probably not going to happen during at least the initial run of these laws. And the other thing that applies here is that the employee has to be unable to work or telework. So with the rise of, as we've seen, teleworking and work from home, you know, there are a lot of employers that may not have to pay paid sick leave because the employee is capable of sitting down with their laptop and still, you know, being able to work from home. So unfortunately, in the case of the employee who's being told to stay at home, if they're being provided with the ability to telework from home, they're not going to be subject to the paid sick leave laws.
Okay, we did that in amazing time, and I think that there's, you know, more to cover, and thank you for sharing those websites. Kelly, can you share that unemployment website that you mentioned earlier one more time?
Yep, it is unemploymenthealth.ohio.gov.
Wonderful. Okay. Well, thank you both so much for your expertise and your very thorough explanations. This has been super helpful, and we will, you know, people can stay in touch for more public info sessions. And again, if you need legal help, you can reach us at cincybar.org/LRS. We'll put a link on this video, and I hope you both stay well, and thank you so much for your time.
Thank you.
Thank
See you
you.
later.
Bye.
Okay. Bye. Bye, Matt.
Goodbye.